Okay, 873 in the matter of Watertown. Good morning.
Good morning, Your Honor. My name is Terry O'Neill, and having heard that last discourse, I'll be 71 in July. I'm going to come here more often. I feel like a young guy, like a kid in this group. I'm afraid we will be here more often. There's 4 points from the beginning that put this case in perspective. Despite some rhetoric in the affidavit of the union president, this is not about negotiations. This case is about the city's effort with a proposal to control supervisory functions where we have 1 supervisor for every 1.8 firefighters in the city. The case law, I want to remind everyone who's read the briefs, we've limited ourselves to almost exclusively Court of Appeals cases. I raised that it's kind of an unusual thing to say, but I had an oral argument recently with Mr. Lambright where he said my cases were old. And I said, yeah, old, but they haven't been overturned in the Court of Appeals cases. So that was in a Public Employment Relations Board context. And thirdly, the framework he puts on this, the union president's affidavit about this is discovery. There's nothing in here about discovery. And then he goes on to say something that I've repeated over and over again, that he was taught or learned or heard that arbitration is trial by ambush. Well, I've been doing this for a very long time, and that's what I heard when I started to be a labor lawyer. And then I have the case, unfortunately, in the state where I found out that it wasn't. I thought
No, we understand all that.
Okay. And then finally, just an overview about this being a classic case of trying to get something through arbitration that they have not secured in negotiations. The grievance, as you go through the steps, make wide and broad allegations about standard operating procedures, past practices, past agreements, things that, and then they tie it to some articles in the contract which frankly have nothing to do with captains. In fact, if you look through this contract, I don't think you'll find a clause other than the salary schedule that talks about what captains get paid that says anything about the captains. And yet they're claiming somehow based on upon information and belief, which we heard for the first time in his affidavit in this case. No one had ever told us that the city had ever agreed to have a captain on each piece of apparatus. And clearly, the contradictory evidence is that they've asked for that many times and never successfully got it put in their contract. So there's, all of this goes on in the first couple of stages when we're asking, they won't meet, they won't talk, they won't explain. And we're not asking for theories of their case, we're not asking for things of law, we're saying, well, what standard operating procedures are you talking about? What provisions in the contract? When you say we violated all the provisions of the contract, they can't possibly mean that. They're not talking about uniforms here. They're talking about manning and staffing. And they sort of backed off some of this in their most recent papers where they say the standard operating procedures, we were only saying that they're useful for interpretation of the provisions. Well, that's not what their grievance says. That's not what their demand for arbitration said. They say the same thing now about past practices because we don't have a past practice clause in this contract. And if you're alleging that an employer in the state of New York violated a past practice that involved terms and conditions of employment, your remedy isn't to try to sneak it into arbitration. Your remedy is to go to the Public Employment Relations Board and say you can't do that, that would be an improper practice. And yet, you know, all of that was in their demand for arbitration. And some of their claims, I have to admit, I've been doing this a very long time. I've never seen anything like this where I always say it's like trying to pull a handful of Jell-O. Everything keeps slipping out because at arbitration, they claimed one thing. A few days later, the union president writes a letter to the city manager and says, no, that's not really what we mean. We're taking away the claim about the captain's positions being, they call it demoted. They actually were abolished and bumped back to firefighters. No one lost their jobs here. But at that point, they say one thing, and then again, they change that to say what we really want. Finally, now this is well after the demand for arbitration, what we really want is a captain on each piece of apparatus. And that's why we have evidence in this record about, yeah, you asked for that. You asked for it at least 4 times in negotiations, and then You might be asking for a table of organization that spells out how many people we'll have in all of these classifications. They did that in the most recent negotiations. They withdrew that because we claimed it was improper to pursue that proposal to interest arbitration because it's a non-mandatory subject of bargaining. So when, now that they've gotten to that point, they now are really seeking what we've called in our papers a manning by rank, which there's nothing in the contract. We have minimum manning. That's, from the city's perspective, that's bad enough. We're dealing with that in different ways.
And that's the whole issue. The whole issue is what is the nature of it, and then we look at the agreement to see if it encompasses that.
Well, it's the court's job to do that, by the way, to see if there's any reasonable relationship. But I think what the judge got wrong below, he found a reasonable relationship with a minimum manning clause that said basically we have to have 15 people on duty, as opposed to what they're trying to get here is how many captains you're going to have on duty.
Right, whether the city must maintain a minimum amount of captains on each shift.
Exactly.
Yep.
Something that is nowhere to be found anywhere, or even a hint of it anywhere in the contract. And, you know, the people wonder sometimes why employers fight, including myself, over things that go to arbitration. And this is a good example, because when you go to arbitration, as you well know, your employer surrenders a lot of procedural and substantive rights. And there are a lot of good things about that.
We understand all that.
Okay. Give me a second, Your Honor. We have filed an improper practice charge related to them refusing to give us the information. This is where the prong about something that's prohibited by law comes in, because under the law, PERB has exclusive non-delegable jurisdiction over that part of the grievance. The confusion here, there's so many issues that they've now tried to throw in. We've tried to deal with each of them in the grievance over I call it 3 prongs. It's really 2 plus 1. The illegal part relates to the PERB charge. The second part relates to what we agreed to arbitrate. So they say, if you get past that prong, have we agreed to arbitrate these things? Well, the difference between minimum manning and manning by rank, they're both non-mandatory subjects of bargaining. You don't have to negotiate them. They did. They negotiated how many men you'll have on duty. Now they're saying men means captain. That can't be the prong that you use to get this into arbitration. And they say with overwhelming contradictory evidence and upon information and belief. But when we agree to minimum manning, we understand if we go to 14, they can arbitrate that. We're not fighting over that. But they can't tell us you've negotiated and agreed to a minimum number of captains. And they've tried to do that in each and every, at least since shortly after arbitration, because that's the first time it came up. Whether something is a broad arbitration clause, again, we say it's not. This is a kind of a unique arbitration clause, and frankly, I haven't seen one like this ever, but it has sort of a dual definition of a grievance. It defines a grievance very broadly. Standard operating procedures, rules, regulations, not practices, but it does those 2 things. And yet, when you go to arbitration, it says the arbitrator is limited to interpreting the contract. And there's a big difference that's very important to understand there. We don't negotiate the rules and regulations with them. The city manager has nothing to do with them. The the city council has nothing to do with them. It's something that the chief does. So the chief sets the standard operating procedures, and we haven't negotiated them with the union. And to now say those should be subject to arbitration, when the limitation on the arbitration is as terms of a contract, which we negotiated, we put in the contract, and we included them, that part we understand, but not the rules and regulations. The same holds true for the past practices, and again, I think in their final papers, they sort of backed off of both of those and claim, notwithstanding what the demand for arbitration says, that they're not asking that those be arbitrated, they're asking that they would just be aids to the arbitrator in finding out what the contract said. And there's a number of very important parts in here that the last argument I made about them not saying upon information and belief, there's no response in their papers to that argument. There's no response in another major argument we included in here also. The one part that I will not go through because I think it's very adequately covered is the conditions proceeding. And the only thing I'll say about that is that that's your decision. There's a Court of Appeals case in here that says that in our briefs, that whether they've satisfied the condition proceedings, and they keep telling us, we'll let the arbitrator decide that. There's a reason we don't go so easily to arbitration in this state, and I'm sure you're all familiar with Johnson City case. It's a Court of Appeals case where basically what the court is saying, to enforce a no layoff provision, we have to protect the citizens of the state, and they put certain requirements on it. And in fact, they have a very important sentence in there where they say, if we don't do this for the public, if we let anybody negotiate any kind of clauses not knowing the implications, it's not fair to the people who live here. And they basically said, otherwise it's going to be subject to and this is a quote, the whim of an arbitrator. And there's a reason we fight so hard about this, because these things, if we agree to them, you want to talk about the minimum manning? You want to talk about that, whether we can fall under Johnson City? But here, where we haven't agreed to something, you shouldn't be forcing it into arbitration.
Okay.
Thank you.
Good morning, Nat Lambright from Blitman and King for the respondent appellant.
Yeah, as I understand your opponent's position, it's, the first issue is whether the preclusion by statute, by the city filing the improper practice with PERB, that therefore, that's the exclusive jurisdiction. So that gets them there, so to speak.
That's one of their arguments. I mean, they're suggesting that because they filed a charge against us based on a failure to provide information, that's the allegation, which has not yet been decided by PERB, and most likely it's going to be deferred to the arbitrator should this go to arbitration. They're suggesting if they bring a charge against the union, that this matter should be stayed by you. Well, that would pretty much put the staying power out of your hands and in the hands of the parties. Anytime anybody brought a improper practice charge with PERB, under that theory, that would be stayed. That makes no sense. Obviously, the other claim that they're making is that the exclusive jurisdiction of PERB is for past practices. We're not bringing a charge that's independent of the contract, as we've said. This is based on Article 5 of the collective bargaining agreement and Article 4. So there is no claim that this is just a past practice independent of the contract. I don't pretend to be an expert, but I do know something about labor law, and if this was an independent past practice claim, I would be in PERB right now. I would not have agreed with this. So,
okay, what about the other issue they bring up relative to the failure to comply with the conditions preceding steps 2 and 3, or whether it is a condition preceding?
well, first of all, the union did comply. The union had to, the grievant had to go to a supervisor. He did. Then the grievant had to set forth a grievance, setting forth the facts and what the grievance was. The grievance on page 84 and 85 of the record is almost a full page, single-spaced. Been practicing labor law for 20 years. Most grievances are one line.
Yeah.
This was a pretty detailed grievance.
Yeah, and one of the arguments, as I understand it, is that, it's really hard to determine what exactly the grievance is. So you tell us what the grievance is and why it is, subject to.
Sure. The grievance is twofold. The first is the city violated the organizational structure and the staffing of the collective bargaining agreement as set forth in Article 5 when it decided to utilize one captain, strike that, 3 captains as opposed to 5. And in other words, they no longer were going to use 1 captain for each of the rigs. They were only to use 3 captains total. There's 5 rigs. So what happened here was when they demoted or abolished A positions, the union said, well, they're no longer to be staffing all the apparatus in accordance with the collective bargaining agreement.
In your position, that's not a salary issue, that's a minimum staffing issue, even though they don't use the word captain.
Correct. And specifically what the CBA says is that they have to have 1 man, and they do use the word men, on the pumper and on the ladder and on the rescue. It's the party's practice, it's been the SOPs of the department, it's been past agreements between the parties, it's been the interpretation of the agreement that word men has always meant 1 captain and at least 2 firefighters on the engine and the pumper. on the engines, and one captain and 2 firefighters on the ladder, and 1 captain and 1 firefighter on the rescue. That's been the practice. That's what the parties agreed to.
In that regard, are we entitled to consider evidence as to whether or not this is arbitrable? The evidence that that issue was previously negotiated and not agreed upon by the city. I mean, if you say it's standing operating practice, but forgive me for glomming on before letting you speak, but to finish the idea, if that's standard operating practice, but it was raised during negotiations and the city refused to do it, how do we then say you're bound by standard operating practice?
The fact of the matter is, Your Honor, the city raised that they wanted to get rid of a total number of captains and negotiations, and the union refused that. These are all issues that are going on between the parties. Union says they have to negotiate it. City says we're not going to negotiate it. It's in fact something that they've disagreed. There's a dispute as to whether it's in the contract. They asked for it to get rid of it. We refused. This is in the record. This is part of the affidavit. This is the history of the parties. So if you were to extend it, consider it, Your Honor, what you'd find is that the parties disagree as to what's in the contract and what the contract means. You're getting into the weeds here. This is what an arbitrator is typically supposed to consider: the bargaining history, the past practices, what the contract language means. That's for an arbitrator to decide.
But to try to find out what the contract means, don't we look at the history between the parties?
That's what an arbitrator typically does. See, you're getting into the merits of the grievance here, not the arbitrability of the grievance.
What was your second point? You said there were 2 points in the grievance. The first was organizational structure, right, and I didn't get your second.
The second point was an out-of-title pay. That's the Article 4 grievance. And that essentially saying when these firefighters are acting as captains, they need to get paid at the captain's rate. That's set forth in the grievance as well. We have a dispute as to whether that's excluded because those are salaries that they'd be paid. Well, we consider salaries to be what you make at the end of the year. Out of pay is something you get every other week.
Yeah, so let me make sure I understand your argument. So as long as the subject matter of the grievance is reasonably related to the general subject matter of the CBA, and that you're saying when you were responding to Justice Kern, your position was the fact that the CBA is silent on minimum staffing levels for captains really goes to the merits of the grievance, and that's for the arbitrator to decide.
Right, and I wouldn't agree.
Not a concern for the courts? Is that?
Well, I would take slight issue, Your Honor, with it being silent. I mean, it's our position that the work.
Well, best case scenario,
right?
Is, but your position, as I understand, is maybe men, and equals captains.
Men equals captains and firefighters in accordance with how the parties have interpreted that language for decades. Now, it would be unreasonable for the city to say, oh, you can't have women? You can't have women because it says men? No, I mean, that's not, men has to have a definition, and it's a definition given by years and years of practice and by the parties at the bargaining table. So he suggests, Mr. O'Neill suggests.
Because everybody knows you're not going to send out X amount of men, and there's not going to be some type of supervisor such as a captain there.
Well, that's actually going on in Watertown.
Okay.
It's a disaster. I would just say there were numerous cases cited that I'd like to respond to very quickly by the city. Newfield, Westchester, Binghamton, all these cases where the city or the employer, it was stayed. In those cases, unlike ours, there was no colorable claim. In Newfield, the CBA was totally silent on subcontracting. In Westchester, the CBA was totally silent on whether the grievance procedure covered 207C claims, GML 207C claims. In Binghamton, it was totally silent on manpower issues. In Cohoes, it was totally silent on 207A cases. In the Syracuse PBA case a couple years ago here, the CBA was totally silent on overtime work when the police officers were volunteering at the airport. The cases that they cited are those where the contract was totally silent. This is not that case. In this case, you have a reasonable relationship to the general subject matter.
And that's the point, the standard for us to review it on, and as I outlined.
Not get into the weeds of the merits of the dispute. The other thing I would just add, with respect to the suggestion by counsel that the union's affidavit, the president's affidavit, is somehow non-admissible or non-probative because it was upon information and belief. Again, the cases cited by the employer in opposition to that are citing cases dealing with declaratory judgments and summary judgment cases. This is a case where these issues need to get in front of an arbitrator to be decided. I'm certainly going to be arguing at that arbitration, should we go, and bringing in witnesses from all over the country who are going to say this is exactly what this provision means. And again, we're not here to litigate what the provision means, we're here to litigate whether or not it's arbitrable to get in front of an arbitrator to see what this provision means. I think that is my last point, but I guess I'd say with respect to the claim as to whether or not the union complied with the grievance process when it set forth the grievance and the facts. What the city is asking you to do here is really to get into the weeds of when a grievance is filed and what is stated in the nuts and bolts of the grievance. Every contract I deal with says, set forth the nature of the grievance and the facts related thereto. If the court gets into whether or not these are adequate facts or that the union did enough job, you're going to have litigation going up the wazoo here.
Yeah, our review is limited to the language of the grievance and the demand for arbitration, and looking at the agreement as a whole.
Do you have any other questions?
No?
Thank you.
Thank you.
I don't know if I'm allowed any.
No, we don't allow it. I'm sorry. Thank you.